It started out with a little boy and some candy cane pens. Now it's a challenge to free speech for students everywhere.
Well, really this started with one little boy, an 8-year-old boy, Jonathan Morgan, who had learned a really neat poem called The Legend of the Candy Cane, and they were having a party at school, which should have been a Christmas party, but they called it a winter party. And when he arrived to give his gift, which was a candy cane pen and the legend of the candy cane, which mentioned, Jesus and a religious aspect, he was actually, stopped at the door by the principal and his teacher and told, you can't bring your gifts in because it has religious things in it.
This is the CitizenLink Report. I'm Stuart Shepard along with Bruce Hausknecht, our judicial analyst. Hi, Bruce.
Hey, Stuart.
We're talking today about an unusual case that was heard by the Fifth Circuit Court of Appeals, and it was decided earlier by a 3-judge panel out of that circuit, which ruled in favor of free speech for the kids. But then the entire court, 16 judges in all, decided to hear this en banc, as they call it. That's when they all gathered together. So it's a second time around at the appeals court, and this time there are a couple of lead attorneys that are definitely worth talking about. We've got Ken Starr and Paul Clement. Tell us what you know about them.
Yes, well, they're both former Solicitor Generals of the United States, which means they are the top appellate lawyer for the administration. And they argue to the Supreme Court all the time because they're the best at what they do. And Paul Clement is most recently in the news because he's going to be taking up the defense of DOMA on behalf of the House of Representatives.
The Defense of Marriage Act.
That's right. And Ken Starr was the most known, I guess, during the Clinton administration as the independent counsel that looked into the Monica Lewinsky scandal.
During the impeachment time. And interestingly, one more little fact about Paul Clement, he's the guy who decided to defend the Defense of Marriage Act, but then his law firm backed out. So he switched law firms. He was one of their star attorneys, and he just left and found another place to go.
Right. Well, you have to commend him for that because that was a very ethical thing for him to do, and quite frankly, we're better for it.
Yeah. Our friends down at Liberty Institute, it's an organization in Texas that we're proudly associated with. Kelly Shackelford and the other attorneys there at Liberty Institute are representing the students in this case. They interviewed for us both Paul Clement and Ken Starr. First, each of them talking about the impact of this case when it's all said and done.
Well, what's at stake in this case, I think, is really the rights for students to be able to have an equal right to speak on religious topics as other topics. And I fear that the other side in this case really wants to turn back the clock and change clearly established law in a way that would allow school districts to discriminate against religious speech.
It's absolutely clear under the law that elementary school children have rights, including the rights for their religious beliefs to be treated the same and equally in school as beliefs about other issues, about politics or issues of public policy, or whatever the issue that might be, that religious speech should not be discriminated against. And that's the allegation in the complaint that was brought here, that religious speech by little children is being singled out and punished.
Following that, they asked, what would classrooms look like if this case goes against the students?
Well, it would look very different than, I think, the way we've always understood it, which is to say that if there are no First Amendment rights in elementary school students, for elementary schools, that means that students can't pass messages to each other, they can't pray together at lunch or other non-curricular times if they want, or based on the facts of this case, they couldn't even give a gift to one of their best friends after school, because all of that would be forbidden. The elementary schools would basically be a free speech free zone.
Well, it would simply reinforce the trend toward a very secular society, and it would send a very unfortunate message that I happen to think is an unconstitutional message, is that the government, our public schools, should be hostile to religion in general and Christianity specifically.
Not exactly the kind of school system we want our kids going to learn about the freedom of speech, freedom of religion, those kind of things.
Yeah, you'd think we want our public schools to be teaching our kids what the Bill of Rights means, especially freedom of religion, freedom of speech, and all that. And to be told that that kind of speech is off limits in the school is something that all Americans should be afraid of.
It would quite literally put the school system in charge of what our children are allowed to say out loud for 6-8 hours a day.
That's right. And if the government is controlling the speech in the classroom, you are going to run across violations of what parents want their children to hear and say in the classroom.
Now, if it strikes you as unusual to have 16 judges in the room at one time, all in their robes, it had to be quite a crowd at the front of the room. It's also unusual for attorneys to see that. Ken Starr comments on what it's like to talk to an en banc panel.
It's very unusual and it's highly significant. Usually courts of appeals sit in panels of 3 judges. Only several times every year will the court come together to sit as is called en banc, which is simply a fancy Latin word for meaning every judge gets on his or her horse, rides into New Orleans, and hears the case. It's very unusual.
And finally, we asked Paul Clement what drew him to the case and to working with Liberty Institute and Kelly Shackelford.
And part of that is the persuasiveness of Kelly Shackelford, and part of that is the importance of this case. This is not a case that's just another case. This is not a case where the principles are unimportant. This is a case that really, it's about first things. It's about first principles. And for a lawyer, I think the First Amendment is something that almost every lawyer holds as being very special. So the opportunity to get into a case like this and to try to vindicate the rights of the Barnett sisters and Jonathan Morgan and Stephanie Varsher, that's a really special opportunity.
Now, Bruce, that's the view from the 2 lead attorneys, 2 very high-powered attorneys who were in the courtroom. But it's good sometimes to take a step back, someone who's not involved in the case, to get a perspective on it. That's why I wanted to get your thoughts on this. What do you think about this? What's really at stake in this case?
Well, there are a couple of prime issues. One is whether elementary school students are privileged under the First Amendment with the freedom of speech and freedom of religion. The fact that these principles shut them down in terms of private speech, giving away candy cane pens to their classmates, invokes that question, whether or not they have the same freedoms as you and I do. But the other question going on in the courtroom is whether or not principals can violate students' civil rights like that and get away with it by saying, well, we're not really sure what the First Amendment says, or our school's lawyers told us to do this.
Now, earlier in this case, the attorneys for the school district from Plano, Texas, argued that this was about students not having free speech rights like adults do when they're in the elementary school classroom. But it appears, the way that the arguments went earlier this week, that the attorneys are backing off of that argument a bit. They're kind of moving away from it.
Well, I think that's wise on their part. Number one, because the Supreme Court has settled long ago, probably 70 years ago, that the First Amendment applies to elementary school students. And I think what they're relying on is, well, there is some gray areas around what type of speech is allowed in elementary schools, and therefore let's not hold these principals liable for their violations of the civil rights.
But on the other hand, the question then becomes, can a principal be held accountable while acting in his or her official duty if he or she violates the free speech rights of a student? The school district is saying, oh no, you can't really sue a school district.
Yes, that's what they're saying. And if we allow principals to get off the hook, then what we're saying is, for the future, any principal can violate any student's civil rights anytime they want, and then they'll just hold their hands up and say, oh, I didn't know, so you can't hold me liable. Well, this case will hopefully allow people to hold those school administrators to the letter of the First Amendment.
All right. Now, everybody involved with this, I think, has an expectation, and no matter which side loses, they will appeal this to the Supreme Court. This could set a precedent, quite literally, for the entire country.
Well, anytime you have student speech in the First Amendment, and you have the opportunity to set new law with regard to the First Amendment at the Supreme Court. This has a lot of procedural things to go through yet, might still go back down to the trial court before it comes back up and on its way to the Supreme Court. This may last years.
Yeah. Now, I want to give you one final word here, and that is, if you could speak to students out there and the parents of those students who are in public schools and elementary schools, what's your encouragement to them as far as standing up for their rights to free speech?
My encouragement first is parents, stick up for your children's First Amendment rights. Tell them what they are. And when they come home from school with stories like we've heard in this case, go to their defense and enroll people like Kelly Shackelford or those types of lawyers to defend you if you're not getting a sufficient response from the school. You have First Amendment rights. know them, protect them.
All right. Well, thank you, Bruce, and thank you for keeping up with all this and helping the rest of us understand it. That's a valuable gift. And thank you for watching. We always enjoy hearing from you. You may write to us at mail@citizenlink.com. We encourage you to pray for the folks who are representing the students down in Texas. The young man who brought this case was 8 years old when it started. He's now 16. Just pray for his peace of mind and that of his family as they continue to proceed through the court system with this. And remember, stand tall and be heard.